furnish the copy?
Yes, Lord. Kindly have page 76, 77. Because by virtue of section 17, by virtue of section 18 of the PC Act, which Manoj will find at page 75 bottom. Page 75, bottom of the page. Provisions of Criminal Law Amendment Ordinance 1944 to apply to attachment under this Act. And Manoj, that ordinance Manoj will find which is actually an enactment at page 77. Manoj, before this enactment would be deployed against my client who is not a public servant for an offence which was committed purportedly in 2014. Charge sheet filed sometime in 2020, and they go after my property on the basis of a bald affidavit without any annexures, without any material, except a bald affidavit to say that it is proceedings of crime. Now, kindly see the intent of the law.
What is the main case?
One of the main cases, it is their case that my company used to deal with transfer development rights, TDR, and I purchased that TDR from certain persons who were not actually the owners, even though their name admittedly was there in the revenue records. After purchasing the same, I sold it to certain persons, and this act of purchase was in collusion with BBMP officials. Why they say it is in collusion with BBMP officials, Lord? Because they say that the persons who set themselves up as owners were not the owners. Even though in the entire charge sheet they are not
long form TDR. What is the long form of TDR? Transfer?
TDR is transfer development right, Lord, where any citizen under the law can offer his property voluntarily, and in exchange he will be given a certificate. And that certificate he can use for constructing more than what is ideally entitlement. There is entitlement. So instead of land acquisition, this TDR facility is there.
So handing over to the authorities.
Sorry, Manoj.
You will hand over it to the authorities.
Sorry.
Do you hand it over to the public authorities?
Right. The citizen hands over the property to BBMP. BBMP hands over a certificate which they call the TDR certificate. That TDR certificate he can use in the designated place to build further in another place more property or a higher floor.
Hence, they are providing him a substitute.
Substitute instead of compensation, which would be the case under Land Acquisition Act. So this TDR concept is there in Karnataka by virtue of an act. It is not there in Delhi.
So what is that act?
Whereas there, if they need land, they simply go for Land Acquisition Act. They acquire the land.
This is under the Land Acquisition Act.
This is under the Karnataka Act.
What is that Karnataka Act?
Karnataka Land Revenue Act.
No.
Karnataka Land Revenue Act.
We are not aware. You have to show us everything.
I'll show it. Kindly
see, these activities should have some force of law.
Sorry,
these activities should have some are regulated under certain law.
It is not in dispute. It is not in dispute.
It may not be in dispute between you, but you should enlighten us on that.
Certainly. But I just get the act words.
Because this matter was in office objections. We have not gone through the file.
Right. I'm sorry. But as far as this particular element is concerned, kindly have page 69.
Page 69.
Page 69, that is their case.
Page 69.
Yes, sir. But page 69. In fact, I would request for to have page 68. That is their highest case, the best case. This is their evidence. The BBMP notified a portion of land heading survey number 132, Bangalore East Taluk, along with other lands for road widening of Batarahalli Road from TC Palya Junction to Outer Ring Road, while so-and-so number was dated 29/7/2009. It offered to compensate those property holders who were losing the land of the buildings with development rights certificate and invited the property holders to apply for the same. So unlike land acquisition, this is a voluntary act. Nobody can be compelled to part with the land. In the said survey number 132, an area of 6 acres 22 guntas was re-granted to Mr. Marappa and later was partitioned among his sons Revanna and Papanna on 15/10/1980. The land was further partitioned by Revanna and sons Mune Rajappa and others on 3rd June 2002 into a residential revenue layout by name BR layout and later sold to general public over a period of time in the form of sites in the year 2002 and also in subsequent years by registered sale deeds. The family of Ravenna, now this is important, the family of Ravenna in whose name the revenue record stood in respect of the said land did not approach the revenue department for change of RTC in spite of partition and sale of the said lands as sites in 2002. So, whereas to the world at large, if today I want to purchase anything, I will go by the revenue records. My company looked at the revenue records, found that they are owners, then the onus is not on me to find out whether he has sold it to somebody else and changed the entries in the revenue report. The said Ravenna died on 7/4/2011. Even after the death of Ravenna, the family did not approach the revenue authorities for development rights certificate, as they had already divested the rights over the land and developed into a revenue layout and sites from therein were sold by the time BBMP notified for road widening. Certain persons, namely, this is not my company, I am a director. Certain persons, namely Walmart Realty Holdings Private Limited, Shri Ratan Lal, that is the petitioner, B.S. Surendranath, Gautam, K. Suresh, hereinafter called as brokers, entered into a criminal conspiracy with officials of the revenue and BBMP to wrongfully gain from the DRC, that is Development Rights Certificate, approached and negotiated with the family of Ravenna in early October 2013 and got the said family members of Ravenna to submit application before the Tehsildar for change of Khata RTC to the names of the legal heirs of the late Ravenna, that is Shri Rajappa, Shri Enappa, Shri Nagaraj, Shri Ramaya, Munipana, Shri Ratanma, and Shri Nagamma, and others, basing the claim on the death certificate and the family tree. The allegation is this: they deliberately conceived that the land in survey number 132 was earlier developed into a revenue layout and sites therein sold by registered absolute sale deeds, and further suppressing the fact that most of the purchasers of sites therein have constructed building and are living there. These brokers also approached a few of the site owners in the said survey number 132 in November 2013 and entered into sale agreements with them to purchase DRC in respect of their properties. The Tehsildar and other officials of the Taluka office ordered the transfer of RTC to the names of legal heirs of Ravenna, fully aware of the fact that the notified land in survey number 132 is already sold as sites and willfully not verifying possession ownership of the notified land as on 13/12/2003. Now, allegation against me is this, not against me, against my company essentially. I come to that also. Immediately after the transfer of RTC in the names of legal heirs of Ravenna, the brokers Surendranath, Gautam, K. Suresh, and Walmart Realty Private Holding have entered into sale agreements for transfer development right on 12/2/14. This date is important. By registered documents for purchase of TDR from the legal heirs of Ravenna and registered power of attorney 2 in number from them favoring Walmart Realty Holding Private Limited on 13/2/14. From this sale agreement transaction, the legal heirs of Ravenna received an advance of rupees 2,86,36,920. So my company paid them a lot that they are not at all entitled to, hence thereby obtained wrongful gain and caused wrongful loss to the eligible site owners who ought to have been the real beneficiaries of the sale of DRC or the TDR. Continuing this fraudulent act, the revenue officers of BBMP, namely so and others in conspiracy collusion with the brokers, fraudulently created a spot inspection report stating that the legal heirs of Ravenna are the owners of area of survey number 132, notified for road widening, and willfully suppress the fact that the other site owners have lawfully built up houses and are inhabiting therein. All still recommended that DRC be issued to the legal heirs of Ravenna. Now, Lord, kindly skip this one para. I'd like to come to the allegation. It starts with further. Further, in order to cause wrongful gain to the brokers and to the legal heirs of Ravenna, the representative of Walmart company, namely Amit Bolla, not me, Shri Ratannath is director, hallmark created false documents representing as the application number so and so was submitted at BMP on 26/6/2013, whereas the application was obtained from BMP head office on 22/11/13. This predating is done to sidestep the government notification dated 7/8/13, in which the land value in Kodanandi area was enhanced to rupees 1.50 lakh per acre with effect from 12/8/13 from the earlier rupees 75 lakh per acre. Thus, in order to obtain higher DRC valuation for buildings in the notified area and to eventually obtain the DRC valuation, the DRC of the PDR application was fraudulently mediated in respect of survey number so and so. Now, if I may take notes to the next page, this goes on and on a lot on these allegations. Ultimately, what is there against me? Please have page 17. It goes on and on. Malads will bear in mind, Malads are not dealing with my trial in the criminal case. The trial in the criminal case, even charges are not framed, and final report is not some primary evidence on which basis I can be held guilty today. Presumption of innocence continues in my favor, but this is what they had to say in order to go for attachment. Not kindly have page 17, paragraph 5. This is all there is. That the present application is filed for preventing the disposal of property. This is very important, these words. Property procured by means of offense punishable under 408, 409, 420, 465, 468, 471 by the accused. That I have submitted the charge sheet in the case and I have been authorized to file. Now, one of the key word which appear here is.
So this property situates in that survey number 132.
No. What they have done is, my lord, what they have done is like Prevention of Money Laundering Act. They have said in para 5 that whatever I earned from the illegal, so-called illegal act of purchase and sale of TDR forms the consideration which I paid for purchasing this particular property, which is my residential house. Now they use the kind instance. Present application is filed for preventing the disposal of property, important word, procured by means of the offense, which means at the stage of even seeking ad interim ex parte attachment where I have no right of hearing, a burden was cast upon them to produce at least material to show that this particular property was not brought out of, purchased out of my own funds, but was purchased by the funds which I received from the so-called corrupt activity. That is all they had to show. They don't do that. Now, let us kindly see the date on this particular affidavit, 15 July 21. What does that say? Yes. Now, let us kindly have page 62 for a moment. I only want to demonstrate how the investigating officer committed a malice in law, was motivated and concealed material fact at the time of obtaining ad interim ex parte attachment on my property, where I am living with my wife and family. Kindly have page 62. What is that page 62?
This is 2020, no?
Sorry, what?
It is 2020. 15/7/2020.
Yes. This is 15/7/2021. This affidavit at page 73.
21. No?
21.
Not legible.
Page 73, the verification is 15 July 21. Whether it is a private citizen or it is the police, both are equal before the court and they must come with clean hands. Now, kindly see page 62. Because page 62 is a document which was filed by the investigating officer on 9/11/20 before this Honorable High Court. At the time of opposing.
62 is some table.
Well, it's a table, yes. Now, this is the table which shows where the money went. I showed Maraj page 73. I explained the chart.
Where is that? No, you were submitting. It is submitted on 9/11.
20.
Where is that?
Maraj, this is part of my affidavit which is not assayed. I only have my affidavit, Maraj, that Maraj will find at page 108. Page 108, paragraph 3, annexure. page 108.
Yes.
Kindly see the bottom paragraphs, paragraph 3. Again, no cross-examination.
This is before the trial court.
This is before the trial court. What
No,
really happened?
even this page number 62.
No, this is before this honorable court. But they attached my bank accounts. They attached Walmart's bank account. They attached many people's bank account. And in order to show to this honorable court that look, this is how the funds are proceeding, they filed this particular chart. Now, this chart was concealed when this affidavit was filed in July 2021 before the trial court at the time of seeking ad interim ex parte stay. And at page 108, I have specifically
So now
mentioned
you were submitting that this page 62 was submitted before this court. In
this court on affidavit.
which proceeding?
Whereas when they sought my bank account attachments, I challenged it before this honorable court. So in counter to that particular proceeding, they filed it with an index and duly signed by the same item.
What was that case?
Sorry, what?
What was that case?
But that was in this very case, they had attached my bank accounts as well.
We are not.
May I clarify?
You say that this page number 62 was submitted before this court.
Yes.
He asked in which press, because this appeal is of the year 2022.
Yes.
You said it was submitted in 9/11/2020.
20.
What
That I get it from page 108.
which proceedings were pending before this court at that?
Whereas my petition challenging the attachment of my bank account.
What was that case number?
Whereas that case number, whereas we'll find 640. Kindly have page 108 plus.
108.
May I make one submission, Lord?
Paragraph 3.
Yes,
I'm sorry to intervene.
he's trying to clarify. Yes. Yes.
108 paragraph 3.
What was that case, Council? You
Lord.
are aware?
Yes, Lord. That was a case wherein, Lord, the order of Lord, the freezing of the bank accounts is subject matter of challenge. And this honorable court had rejected, Lord, the petition.
Was it a criminal appeal, criminal petition?
No, criminal petition, Lord.
judicial-
Criminal petition. But one request, Lord, if Lord will grant me some time, I place those orders on record. It will make some difference. The reason being,
criminal
Lord,
petition number
Lord,
646 of 2020.
yes, Lord.
46 of it. Let him complete. We'll
Very well, very
grant
well.
some time.
I'm justifying what I'm saying. When the IO goes to the court and invokes criminal amendment ordinance and tries to get an ad interim ex parte attachment, he's supposed to go to the court with complete facts. Now, at page 108, I disclose what I showed was at page 62. Please have page 100. This is my affidavit.
Yes.
Paragraph 3. Kindly have paragraph 3. I say that the IO of the case has filed a memo before the Honorable High Court in criminal revision petition number 646 of 2020, while defending challenge to the attachment of various bank accounts, including my account bearing number so and so ADA number. It is now a matter of record that the judgment which came to be passed in the said petition came to be set aside by the Honorable Supreme Court of India. Now, this particular chart, my lord, form part of what I have mentioned, criminal revision petition 646 of 2020. It was on oath. It was filed before this court, so it can't be a lie. Now that chart shows, my lord, that on the date that I purchased the property, please have 62 for me. I'm sorry, I'll be taking notes to 2 pages, 62 and 108, 108. No cross-examination on this, accepted. It is sideways, Lord. Kindly see at the top, Lord. What does it say? DRC number 2924 dated 1414. This is the development rights certificate which is in dispute. What's that? At the top, DRC number 2924. Top left hand corner.
Yes. 2924.
Yes, 2924 dated 1414. Now kindly see below that, paid towards purchase of aforesaid TDRs. A chart was given by the IO to show that look my lords, don't release the bank account. This is the kind of money transfer which has gone. Please see now. Serial number 1. Brothers have the date 30th July 14. Brothers area and square feet to whom sold, sale consideration, purchase, brokerage, total cost. Now this is important word. Distributable gross profit. Brothers have that column.
Yes.
46 lakh 71,000. But no, that is not important. According to the prosecution, on 30th July 14, a sum of 23 lakh only was received by Walmart. Please see this VRHPL. Next entry VRHPL. Next to distribution, distributable gross profit.
Where do we find this?
What is, on the top, distributable gross profit, on the next column, VRHPL. Notice that?
Yes, what is this
Please see the
VRHPL?
amount.
What is this VRHPL?
VRHPL is what they are calling short form of abbreviation of Walmart Realty Holding Private Limited, my company where I am a director.
Yes.
But next entry BS Surendranath, next bottom K, next Suresh K. There is no name of the appellant in this. The appellant has not received any money from the so-called crime committed in sale of TDR. And interestingly, my lord, please mark this entry 23 lakh 35,536 VRHPL. But my date of purchase of the property is 6 August 14. It is the admitted case of the prosecution that the date of purchase of the property is 6 August 2014. So as on the date when I am purchasing the property, my lord, going by their case, I have only received 22 lakh rupees and not me, my company. But if I received 22 lakh rupees on 30th July 14, could I have purchased the property worth 22 crores? It is not possible. So this chart was conceived. And why it was conceived? Now please come back to my affidavit at page 109.
This is received as registration value.
Sorry, what?
It is received as registration value.
Yes. The point being, my lord, if going by their case, I accept their case at its face value. The IO never realized that we produced this chart which he had produced in the Honorable High Court before this Honorable Court. And as per his own chart, as on the date of purchase of the sale deed, my company had only received 22 lakh rupees, and please see the sale deed. Please see the sale deed at page 45, 44. Starting at page 33. Please see the date. Page 33. Annexure B. 7th August 2014. Now, I showed the chart. The only entry which was received from the sale of the TDR at page 62 before 7th August 2014 was only 23 lakhs as far as Walmart is concerned.
Yes.
But it is so convenient for the prosecution behind the back of the respondent to go to the court, make an affidavit, not file documents, and get an order. And I would say it is suppression of fact. And how it happened further, I could not have challenged that order. They would have said you had right to file objection, which I did. So I had to go through the entire gamut of inquiry, get a final adverse order, and then come before my lords. Now this property was purchased on 7th August 14, my lord, when only 23 lakhs was in the account of BRHPL. Now please see my affidavit at page 109. No cross-examination by the prosecution. Page 109, my affidavit. But is there a different test for an individual and for the police? I place annexures on record. I prove any document. No objection is taken. Please see paragraph 4. I say that the memo was filed on 9/11/20. Manoj was asking you for the date. No challenge to that. Containing a conclusive investigative chart depicting details of dates and amounts paid to the alleged accused persons against sale of TDRs to ever that TDR was sold to various real estate companies for a sum of rupees 27 crore 68 lakh 79,201. Certified copy is on record. I say that the said chart index demonstrates that and is an admission of fact that my said property was not procured or purchased by means of the alleged offense. In other words, as per the IO's investigative chart, the funds were received by Walmart from the sale of PDR. There is nothing to suggest in the chart sheet that the said funds are the basis of purchasing the property now sought to be attached. According to the said index, I did not receive a single penny from sale of PDR. I showed my lord, my name is not there. And on the date of purchase, only 23 lakhs. But next para is even more telling, no cross-examination. I will take my lord's cross. I say that it is the case of the prosecution that another accused, namely Walmart Realty Holding Private Limited, a separate legal entity, my lord will mark this word because the trial court accepts this fact that yes, in law it's a separate legal entity, but we'll see. I have to just come to a prima facie case. That's not the law. A separate legal entity of which I am merely a director received a sum of 23,35,536 between the period 30th July 14 and 7/8/14, that is the date when I purchased the said property for a sum of rupees 22 crores 79 lakh 94,000. It is not the prosecution case that I purchased the property from the money received by Messrs. Walmart Realty Holding Private. So, in sum and substance, my case is that whether it is PMLA, whether it is Criminal Law Amendment Ordinance, which is being deployed against me by virtue of 18A of the PC Act, the first test which the prosecution must cross is, and there is a reason, these provisions are not actually in the teeth of what we call presumption of innocence. Normally, I can understand I am going to run away. I am being used in society. For 5 years, I did not sell it. Suddenly, today they attach it. I face the ignominy of somebody coming and putting a seal because the next date is 12th of this month or not. The judges said, report to me whether you have carried out the attachment or not. Where will I go, my lord? Trial is on. I have to prima facie demonstrate that there is no case of proceeds of crime. And I will also demonstrate.
Your position is not taken.
No, the learned judge has said attachment is ordered. Now, by breach of grounds under Order 21, Rule 46, they are supposed to come to a chaspa, what you call asphyxiation. Whereas I am not some criminal. The whole idea of facing a proceeding where they'll come into an attachment or a chaspa on my house, I'm fighting for it. If I was a petty criminal, I would have said, let it be attached. It does not affect my reputation. I'm fighting it to the nail only to demonstrate that they have got the wrong property. And how? There is no cross-examination on para 6 at page 109. Please come along now to the cross-examination. First, cross-examination is at page 112. And because my client satisfied the court that he did not understand the vernacular, it was duly explained to him in English and then noted. Please see the translation at page 160. 170 words. So, because what I showed to my lords at page 109, I showed my lord the chart which the IO relies upon before this honorable court. I showed my lord the fact that on the date when I was purchasing the property, all the money that my company had, not even I, was 22 lakh. So, my lord, 22 lakh cannot become 22 crore to purchase property. And I even demonstrated where my money came from. Now, please see the cross-examination. The chart is not challenged at all. Please see the cross at page 107. Page 118 minutes.
Listening to translation.
That's a translation.
117.
118, 1 minute. Bottom paragraphs. It is false to suggest. Now, why I am showing this to Murad is, but Criminal Law Amendment Ordinance, even though it forms part of a criminal act, as in an enactment which provides for criminal activity or redressal of crime, like Murad's Protection of Women from Domestic Violence Act, it's a civil remedy, but it works inside a criminal frame. Criminal Law Amendment Ordinance, Murad, has been deployed for being used under PC Act. So even though the court is sitting in criminal capacity, even though dealing with a criminal case, the procedure as per the ordinance has to be civil, which means the affidavit which the IO filed has to be like a pleading. The case has to be set out. I file my objection, which is like a WS, which I filed, and then he can file an application, which he did not do. Now, what they do is, for the first time in the cross, they bring new facts without confronting me with any document, because no document formed part of his affidavit, which was the basis of getting an attachment against me. Page 180, last paragraph. It is false to suggest that an amount of rupees 10.45 crore was transferred from Avant-Garde Fashion Wear Private Limited to my personal account. I do not remember that an amount of rupees 8.65 crore was transferred to my account from AJ Shantaram bank account between 27/7/14 to 6/8/14. Witness adds that I produced the bank statement. Now, it's very important. Please bear in mind. Now they changed their case. I showed my lord in their application, they simply got away by making a bold averment that this particular property is proceeds of crime. Manoj will recall that particular application, that Manoj will find at page 72. Because how can they keep on improving their case? First, they get an ad interim attachment order, page 72, para 5. What happens? What I am making as an officer of the court, I am saying so. My learned friend can rebut. This whole new story which my lords are finding at page 118 and 119 is not there in this affidavit. And when I am denying,
Whether in the cross examination they are required to confine to their.
they were supposed to confront me, my lord.
Whether they are required to confine to their affidavit.
Yes, my lord.
Cross examination.
Yes, I come to that. My contention is that because the provisions of CPC were being followed for procedural sake, they were supposed to confine themselves to the original affidavit. And even for the sake of argument, if I bow down to Malad and say they were not, but at this entire averment at page 118, 119, I am not confronted with any document. Because when I am denying all these facts, so they make a new case. Please see, the tone and tenor of this case is different from at page 72. At page 72, they are saying the money which was brought into Walmart from sale of TDR was the basis of the purchase. When they realize that on the date of purchasing the property, money had not come in more than 22 lakhs. How could I purchase a property of 22 crores? So they changed their case in their cross. And how they change it? Page 180. Whatever. They now say, my lord, that some money came in by one company, Avant-Garde. They say that some money I took from AJ Shantaram, and my lords will note neither Avant-Garde is an accused, nor AJ Shantaram is an accused, and at page 119, Lakshmi Narayan Vyapar Private Limited is also not an accused. Because I have never seen, I don't claim to be an expert in trials, but 20 years at the bar, I was taught that if the witness is not agreeing with you, you will pull out your documents and you will confront him with it, giving the witness an opportunity to explain what you are trying to allege, merely by giving suggestions. Like, look, you took some money from here, you took some money from MJ Shantaram, and then you did the needful. Please see next paragraph. On 5/8/14, an amount of rupees 15 crore was transferred to my bank account from Lakshmi Narayan Vyapar Private Limited. On 27/8/14, an amount of 10 crore, and on 10/3/15, an amount of 5 crore. Now, kindly see the line of cross. Property is already being purchased on 6/8/14. Property I showed to my lord has already been purchased on page 33 and 7/8/14. Page 33.
The property was purchased on
7/8/14.
7/8/2014.
And the recitals in the sale deed at page 44-45 set out that all the money has come from my private account, not from Walmart. But see the line of cross alert. Now, even though the property was purchased on 7/8/14, the suggestion is being given that after you purchase the property, then some money came into your account. This is what it means. On 27/18, an amount of 10 crore and 10,315 an amount of 5 crore. How is it relevant, my lord? Now, my lord, interestingly, even though I am not confronted with any document to prove their case, and I have not seen a case, my lord, where you are attaching my property, and your person, the prosecution's IO, does not offer himself for evidence. He does not step into the witness box. He does not submit himself to cross because he would have been confronted with that charge which I showed to you. Nothing happens. But the impugned order is entirely based on this paragraph 4. Entire order is based on paragraph 4 and 5. Kindly see the impugned order. And I demonstrate to Milord how that also came about. Please have page 30.
30.
Page 30 of the impugned order. But if it was enough that in cross-examination, merely by giving suggestion, the party can prove its case, then in every criminal trial, we should have been acquitted. Sorry,
some of the suggestions you have admitted.
I admitted. I'm saying I got 10 crore from somebody and I paid him back with a loan. But kindly see the finding at page 30. Please read that particular page 118, 19 with this finding. Paragraph 13. The learned prosecutor has submitted that from 18,614 to 13,1214, rupees 10.45 crore was transferred from Avantgarde to the Corporation Bank. But I have specifically denied it at page 118. Please see, I specifically denied it, but the learned judge does not deal with my denial because the prosecutor failed to confront me. It is an inquiry, it's like a mini trial. At paragraph 4, it is false to say I am denying it. Now, please see further. Crores was transferred from Avantgarde Fashion to the Corporation Bank account of first respondent. It is further alleged that in between 27,714 and 6,814, during the span of 11 days, 8.65 crore came to be transferred from the bank of MJ Shantaram. Yes, but who's MJ Shantaram in this case? He is neither an accused nor a conspirator. Who's he? He is my friend. But it's very strange. If MJ Shantaram was an accused in this case, if MJ Shantaram was a suspect in this case, charge sheet is wrong fine. Now the matter is fixed in March for argument of judge. But if I took money from MJ Shantaram, in fact, it proves something. It proves that I did not take money from sale of PDR. This is the admission. If I am taking crores from my friends, 15 crore, 10 crore properties by 22, that means their original case at page 73, that this is proceeds of crime, is factually incorrect. Page 72, paragraph 5. It is so easy to make what allegations and get away with it. Page 72, because in the middle of the page, paragraph 5. No mention of MJ Shantaram, no mention of any other gentleman. And the learned trial judge accepts this to the account of, I'm back on page 31. It is argued that the first respondent has utilized the aforesaid amount to purchase the attached property. Now, this is a very important line, page 31. The prosecutor is arguing, without confronting the witness with the accounts and material, it is argued that the first respondent has utilized the aforesaid amount to purchase the attached. From where are they getting this, my lord? From 7,814 to 26,1214, rupees 3 crore was transferred from the bank account of first respondent to account of MJ Shantaram. All this is in the air. This does not form part of the affidavit. Please see all these lines. This does not form part of the cross at page 118, 119. What I am reading now, Lord. From 7,814 to 26,1214, 3 crore was transferred from the bank account. From where? I just read the affidavit, Lord. From where did they get this? Because I tell you what really happened. Because my senior told me when an accused is caught, sometimes our arguments make the prosecution wiser and they cover the case in the case like this. When I started arguing and I showed the state lead and I showed the chart of the IO, they changed the case. And they tried to make a new case that look, probably this property may not be proceeds of crime. but later some money came into your account and that money you return to somebody else and therefore it may be proceeds of crime. So the learned judge holds for what? The document produced by the petitioner at the stage are sufficient to arrive at a prima facie conclusion that the attached property was purchased from the proceeds of crime. And another kindly see, the petitioner is not required to prove the allegations by direct evidence. What does a humbly submit? Under Article 300A, right to property is a constitutional right, if not a fundamental right, and it can only be deprived by due procedure established by law. A man who is presumed to be innocent.
What is the procedure for this?
Yes. Now please come to the procedure. I oblige to Malad. Kindly have the ordinance at page 77. But Malad, before I take Malad to the ordinance, I want to show something glaring. Because the day this cross-examination was over.
No, you see, you were go one by one. You were submitting that IO did not enter the witness box.
Yes.
Now you are under which provision this inquiry is conducted?
Yes.
What is the procedure?
Yes.
On whom the burden lies there?
There is a reverse burden on me, but Manoj, it's a well-established principle of law and rule other case that even in cases where there is reverse burden, the basic case has to be proved by the prosecutor.
Which is that?
Please, kindly have 77. Allow me to read.
Law of Criminal Amendment Ordinance.
Kindly have the bottom of the page, section 3. Where the state government, or as the case may be the central government, has reason to believe that any person has committed, whether after the commencement of this ordinance or not, any scheduled offense. Now, whereas PC Act is added as a schedule. The state government, or as the case may be, the central government, may, whether or not any court has taken cognizance of the offense, whether or not any court has taken cognizance of the offense, authorize the making of an application to the district judge within the local limits of whose jurisdiction the said person ordinarily resides or carries on business for the attachment under this ordinance of the money. This is important for me, for the money or other property which the state government or the central government believes the said person to have procured by means of the offense. Or, so one of the first tests is, first the learned judge must come to a finding, and finding which discloses reasons. Not a finding based on argument of the prosecutor. Finding, yes, there is X property. That property is a proceed of crime, or it is purchased from proceeds of crime. Then if that property is not available, my lord, like PMLA, you can go after some other property, but that is not the case here. They don't say that the property that they have attached today is not the proceeds of crime. They insist that it is proceeds of crime or other property of the same person of value as merely as being equivalent to that of the aforesaid money or property. Now, please, this is important, Lord. The provisions of Order 27 of the first schedule to the CPC shall apply to the proceeding or an order of attachment under this ordinance as they apply to suits by the government. An application under subsection 1 shall be accompanied by one or more affidavit stating the grounds on which the belief that the said person has committed any scheduled offense is founded and the amount of money or value of other property believed to have been procured by means of an offense. But I hope Mulans around subsection 3.
Yes.
Right, twice the lawmaker in its wisdom insists on the fact that before you go after any property, you must be sure that the same is proceeds of crime. You must say so on affidavit. I read further, my lord. The application shall furnish any information available as to the location for the timing of any such money or property, and shall, if necessary, give particulars including the value of the property of the said person. Now, my lord, kindly see 4. Upon receipt of an application under section 3, the district judge, unless the reasons to be recorded in writing is of the opinion that there exists no prima facie grounds for believing that the person in respect of whom the application is made has committed any scheduled offence, or that he has procured thereby any money or other property, pass without delay and add interim order, attaching the money or other property alleged to have been so procured. Or if it transpires that such money or other property is not available for attachment, such other property of the said person of equivalent value. So, my lord, again, first there must be a finding that X property is proceeds of crime. If that is not available, you go after Y property. But they don't make that case. Provided that the district judge may, if he thinks fit, before passing such order, and shall, before refusing to pass such order, examine the person or persons making the affidavit accompanying the application. He does not do so, that's okay, it was his discretion. At the same time as he passes an order under subsection 1, the district judge shall issue to the person whose money or other property is being attached a notice accompanied by copies of the order, the application and affidavit and of the evidence. But it is inbuilt. And of the evidence being recorded, calling upon him to show cause of a date to be specified in the notice, why the order of attachment should not be made absolute. The district judge shall also issue accompanied by copies of the documents accompanying the notice under subsection 2 to all persons represented to him as having or being likely to claim any interest or title in the property of the person to whom notice is issued. Now, I'll skip this. Allow me to come to 5, section 5. Because I've already shown to Malord that CPC will apply as it applies to suit by or against the government. Now, please see 5 is Malord and 5. If no cause is shown and no objections are made under section 4 on or before the specified date, the district judge shall forthwith pass an order making the ad interim or order of attachment absolute. Now, number 5 is important. If cause is shown, which I did show, or any objections are made, as aforesaid, the district judge shall proceed to investigate the same, and in doing so, this is important, Malad, because Malad spoke to me. Where is the requirement of him stepping into the witness box? As regards the examination of the parties, not only the objector, Malad. Right, merely because, like CPC does not say that both parties will step into the witness box, the language uses as regards the examination of the parties, and in all other respects, he shall subject to the powers of a court in hearing a suit under CPC, Malad. But CPC, we are aware, and any person making an objection under section 4 shall be required to use evidence to show that the date of attachment he had some interest in the property attached. Now that I stop here for a moment. Rest of the provisions don't really go any further as far as my petition is concerned. What did I do?
Meeting reverse burden. Where is that reverse?
Well, reverse burden is this 5-2. That is only line. This is the limited reverse burden. 5-2 last 2 lines. Any person making an objection under section 4 shall be required to produce evidence to show that at the date of attachment he had some interest in the property attached. In fact, my lord, this will not apply where there is no dispute as to the title of the objector. I still stepped into the witness box. I made good my affidavit. I placed on record documents to show that my property is from my own funds. Having cross-examined me, having not confronted me with any document, something very unique happens, my lord. Despite CPC applying, the learned judge in the impugn order says no direct evidence is required from the prosecution. We can attach any citizen's property. This is the sum and substance. But something more happens. They realize there is something missing in the case. So after reserving the order for judgment, my lord, a document is filed on the court record. Kindly have, my lord, after my affidavit, page 120. But as the matter is reserved for orders on 20 to 12/21. Manas, page 190.
Yes.
Kindly see the bottom page.
Certainly after deposition.
But there is a reason I am showing this.
119.
190. What a witness only knows English language. On the question asked to the witness, he replied in English language and the same was translated in Tamil. Now, this is happening on 20 to 12/21. is put up for orders. This came in objection, my lord, but so that my learned friend doesn't dispute. The matter is reserved for orders on 20 to 12. May I just pass this certified copy, my lord? First, we remove this because typing it in such a short time. So, interestingly, 20 to 12, 21 cross-examination happens. My cross. The prosecution does not want to field any evidence. Now, please see the bottom right-hand corner. Matter reserved for orders on 6 January. But justice should not only be done, but seem to be done. On 6 January, and I am saying so with full responsibility, I said so even in writing before the learned district judge. On 6 January, when BC hearings had again started, the IO very interestingly, after everything was over, we did not want to the district witness was filed the Kannada report, which neither my client nor I could read at page 120. But is this fair? After reserving the matter for orders, this report is filed, and I am in fact saying so, my lord. This is not accompanied by affidavit as contemplated in section 3. This was not some bail hearing where you just file a status report in the court. And interestingly, my lord, at page 122, he submits a chart.
This is 11 dated 11/21.
Sorry, my lord.
When this
My lord, he backdated it.
when this is filed.
This is filed on 6 January, my lord. Kindly see this, my lord. I will show, my lord, the order of 6 January. But this order of 6 January is at page 132. Page 132, lords. He backdates the report. See, page 132.
The sixth one.
What is that?
It is brought to the notice of the Learned Council for R1 regarding memo filed by Learned PP.
Dated 23/12. And Manoj, there is a noticing it is July, it is even saying November 21. What Manoj are noticing is that it is actually
Dated 16/11/2020. So you were furnished with this copy.
no, Lord. After the matter came to be reserved, evidence was over, prosecution did not want to read any evidence. I am taken by surprise and I am giving a Kannada copy of a document very well knowing that neither lawyer follows this language. I am given it on 6th of Jan when I attend the matter through BC and the local council appears in court, and I am handed over this copy.
So you were assisted by a local council.
That is a fact. But Lord, is this fairness of procedure? I am only saying when CPC was applied, when affidavit was to be deployed inside the
Correct, but your submission that neither you nor your
I think recording and repeating.
Lord, somebody else is sharing the screen, Lord. I think the court officer will have to. Please.
What is all? I'm sorry.
Where is your name? Back hogi, back hogi. Somebody is recording. ನೋಡ್ಕೊಳ್ಳಿ ಏನಂತ
7332 ಅಂತ ಡಿಲೀಟ್ ಮಾಡ್ಬಿಡಿ ಮೇಡಮ್ ಅವ್ರನ್ನ
1332 ಅಂತಲ್ಲ
7332 ಅಂತ ತೆಗೆದಾಕ್ಬಿಡ್ಬೋದು ಮೀಟಿಂಗ್ ಇಂದ ಪ್ಲೀಸ್.
ಇನ್ನೊಬ್ರು ಹಾಗಲ್ಲ ಹಾಗಿದ್ರೆ ಇಟ್ ಶುಡ್ ನಾಟ್ ಇಕ್ಕೋ. ಒಂದು ಸೆಕೆಂಡ್ But mute ಮಾಡಿದ್ರೆ ನೀವು you will be disabled.
ಸ್ವಲ್ಪ ಸ್ಲೋ ಮಾಡಿ.
Lord, court mic is muted, Lord.
Yes, you can hear us now.
Yes, Lord. Yes, Lord.
That's all I'm saying is this. I don't want to make too much of an issue about this. I want the reporting
You
correct.
are assisted by a local advocate.
But there is a reason. This particular report has certain annexures. Let's have the report noted in page 120.
Yes, 120.
Yes. And even though it's in Kannada, I can make out where annexures are marked. Page 120, then we take page 121. Some 12% is written.
Live streaming is going on.